Thank you, Mr. Chairman, members of the committee. I am proud to sponsor H5510, the Protect Rhode Island Families Act, a narrowly focused bill that can help save lives by keeping guns out of the hands of dangerous domestic abusers. Guns and domestic violence are a deadly combination. When a gun is present in a domestic violence situation, it increases fivefold the risk of homicide for women. I became an advocate for survivors of domestic abuse through the work I did in my community, and that work exposed me to the terrifying situation women and children face, and the courage it takes for them to ask for help. As a result, I've worked for the past 3 years with my colleagues in the General Assembly to address gaps in Rhode Island's law that make it too easy for domestic abusers, many of whom already are prohibited under federal law from having guns. The Protect Rhode Island Families Act closes these gaps in 3 ways. First, it amends state law to prohibit gun possession by domestic abusers who commit violent misdemeanor crimes. Mirroring the federal statute, abusers convicted of misdemeanors that involve the use or threat of force or a dangerous weapon would be prohibited from purchasing or possessing guns. Additionally, the bill would prohibit gun possession by convicted cyberstalkers, since stalking behavior is a strong indicator of future violence, and those convicted for violating prior protective orders. So those are 2 new pieces that are added to the bill this year. To date, 27 states and the District of Columbia have passed laws requiring that abusers convicted of misdemeanor crimes be prohibited, misdemeanor domestic violence crimes be prohibited from possessing guns. Second thing this bill does is it would temporarily prohibit gun possession by domestic abusers who are subject to final protective orders. These are not the temporary restraining orders that are issued immediately. These are orders issued after a full and fair hearing at which all parties have had an opportunity to be heard. Federal law already prohibits most abusers who are subject to final protective orders from having guns, and to date, 27 states and DC have enacted laws that prohibit abusers who are subject to final protective orders from having guns. Together, these 2 changes would not only bring Rhode Island in line with federal law, but just as importantly, it would empower local law enforcement to arrest and prosecute those who break these laws. Finally, the Protect Rhode Island Families Act would address a gap in federal law by requiring that all prohibited abusers surrender guns, any guns that they already own, to law enforcement or a licensed firearm dealer. Prohibited persons would fail a background check if they tried to buy a new gun. But Rhode Island currently has no law in place regarding guns they own when they become prohibited. Requiring surrender is a vital step to ensure that newly prohibited abusers don't use their guns to do further harm. Thanks to close collaboration with my colleagues and a careful consideration of the evidence, we have all identified these necessary common sense legislative changes and are unified behind the Protect Rhode Island Families Act, a narrowly targeted and effective bill that will keep Rhode Island families safe. In addition to praising what this bill does, I want to make it perfectly clear what it does not do. This bill does not cover all domestic violence misdemeanors. It would not affect those convicted of the, quote, petty misdemeanors, such as disorderly conduct, or of crimes like trespass or vandalism. This bill is aimed squarely at domestic abusers who pose a clear and present threat to their victims and in whose hands guns are especially dangerous. This bill would keep guns out of the hands of only certain convicted abusers, specifically those convicted of misdemeanors involving the use or threat of force and weapons, or whose crimes indicate the likelihood of future violence. These convicted criminals are dangerous and should never again have access to guns. Additionally, this bill does not impact anyone who is subject to a temporary protective order. Only abusers who are subject to final protective orders would become prohibited. Final orders are only issued after a full hearing, again, after all parties have had an opportunity to be heard. and only if the court determines that the abuser's behavior is so egregious that the order necessary to ensure their victim's safety. Abusers subject to final orders have no business with guns. It is also important to note that these abusers would only be prohibited from possessing these guns while the protective order remains in effect. Once a court has determined that the order is no longer necessary, the prohibition would be lifted. I and my co-sponsors respect the Second Amendment and the right of law-abiding Rhode Islanders to own their guns. This bill has nothing to do with responsible gun owners or their rights. This bill is narrowly focused on two groups of dangerous abusers. First, convicted criminals whose conduct has demonstrated the dangers they pose if given access to firearms. And second, abusers who, after a full hearing, which they have had an opportunity to be heard, are made subject to by the court to a final protective order. These are not responsible gun owners, nor are they people who made a one-time mistake. These abusers have had their day in court and were either convicted for serious crimes or found to pose an immediate threat to victims. We must do all we can to keep guns out of these abusers' hands. For far too long, we have failed to take action to protect the communities we serve and all Rhode Islanders who are victims of domestic violence. The time to act is now. Let this be the year we finally stand up for Rhode Island families and pass this common sense law to protect victims of domestic violence. We owe it to Rhode Island families to get it done this year. And I'm happy to take any questions.